I'm Kevin Heffernan. I'm a law clerk at Jellinek Ellis Gluckstein here in Toronto. I am pleased to be introducing the one of the senior partners at Jellinek Ellis Gluckstein with over a decade of experience supporting survivors of sexual and physical assault. Erin Ellis represents clients from across Canada in civil abuse litigation, securing acknowledgement and compensation for harm caused to individuals, by individuals and institutions. Erin's compassionate, dedicated approach, combined with her extensive experience, enables her to effectively advocate for survivors and tailor strategies to individual cases. Please join me in welcoming Erin Ellis to speak about advocacy efforts and community initiatives.
Thank you. I'm just going to back that up. So I'm jumping the queue, but I've also been asked to reduce my presentation for time because the other two people, much more important than me, who still have to speak today, and we're running a bit behind. So I'm going to shorten what I was going to talk about, but my focus is on some advocacy that our group has been doing outside of litigation. So obviously, we're lawyers, we run cases, we focus on civil law. But outside of that role, we're also involved as board members or involved at various sexual assault support centers, etc. And we've also done some government lobbying or speaking. So I want to touch on a couple bills that have come through this year that I have had the pleasure of being involved in, speaking about and trying to push for change. So the first one was Bill 157, Enhancing Access to Justice Act. The first reading was in November, and it was introduced by the Conservative Party. It had a lot of various schedules with changes to various acts to enhance access to justice. We focused on Schedule 18, which was about the Victims' Bill of Rights. In the Victims' Bill of Rights, perpetrators of specific crimes as prescribed in that bill are liable to pay damages in a civil suit. So the survivor is presumed that there was harm if they were a victim of one of these crimes. And the proposed amendments added to that list of prescribed crimes, but we didn't love the wording of some of them. We didn't think it actually covered the people that we help and the phone calls we receive. So we went and spoke at Standing Committee on Justice Policy. And we suggested broader changes. We also came prepared with draft wording for the legislation, which I think made a difference in the tight turnaround of actually passing the bill. Again, because I'm speeding through this, there we go. So how the crimes as they were before were these three. So victim of assault, if the victim was a spouse within the meaning of Section 29 of the Family Law Act. So only that would address intimate partner violence, but only within the context of the definition of a spouse. A victim of a sexual assault and a victim of an attempted sexual assault. The way the bill, or the way the Act, Victims of Crime Act reads now, there we go. Now there's 7 listed, and we spoke to number 4, a victim of a crime if the crime is of a sexual nature or it involves a sexual purpose. And our thought with that one was that a lot of through the criminal process, a lot of people make plea deals. And so they may not be convicted of a sexual assault, but what happened and how the details are read in at their guilty plea is a sexual assault. But technically it wasn't covered by the act before this change. So this made it wider. And in the draft version in the bill, they did have this change to try and kind of cover that, but it was going to be restricted to people under the age of 18. And we said, why? Why would that be restricted? Why would this change be restricted to only minors? And they listened to us, and that change was made. 5 and 6 was how they drafted it, and then 7 was an addition because of our advocacy. It wasn't in there previously. And so number 7 was meant to cover physical abuse, so child abuse, because that wasn't the way, if you remember from the previous slide, a victim of assault, if they were a spouse, was covered. But what if they were the kid? Then it wasn't covered. So there's these holes in our legislation that people can fall through. And yes, you can still bring the civil case, and yes, you can still prove the damage, but having the presumption on your side I think just makes a difference to people, right? So that was very interesting to be involved in. And then more recently, Bill 173, Intimate Partner Violence Epidemic Act, which was introduced by the NDP. The Conservative government supported the bill in its own way by referring it to committee to have this study on intimate partner violence and what tangible actions can we do, and let's have everyone come in and talk, which was nice for us to come in and talk. We'll see where that goes. They're still refusing to declare it as an epidemic, for which led to heated debate yesterday. But so myself and Vanchika went and spoke at the committee, and what we focused on there was the Victim Quick Response Program and compensation for survivors. So yes, those changes were made in the other bill to the Victims' Bill of Rights, but that only goes so far, right? It's only if there's someone to sue does that even help. So we get calls all the time from people, and we have to say there's no one for you to sue. We don't want to, as Linda talked earlier, you don't want to drag someone through a litigation process if there's no compensation at the end of the day. So what we used to refer them to was the Criminal Injury Compensation Board, which has been tossed. So we're trying to get changes to the Victim Quick Response Program that could maybe be similar in its help to our clients. I have a lot more to say about that, but I will not take up the time. This bill is also making its way through. It was introduced by the Conservative Party, Erin's law. It models with some of the similar laws that were passed in the US. It started in the US. It likely is being passed, I assume, introduced by the Conservatives, will go through. And so it would amend Ontario's Education Act to require that the school boards establish policies to provide students with age-appropriate resources for recognizing childhood sexual abuse and reporting it to a trusted adult. It's currently in committee. It's good things, these small changes. So I get really upset when I see the political climate right now, right? And for many reasons, my area of practice being one of those, and help for survivors being one of those. Help for survivors shouldn't be a partisan issue. It tends to be still, but there are little changes that can be made. And that's where, those changes to the Victim Bill of Rights, that only helps a small percentage of people, but at least it's moving it forward a bit. That's our mindset. What can we do within what exists right now? And then if there's someone with, who's going to lend us a bigger ear, then maybe we can push more at other stages, but keep trying to push the needle even when there's some resistance. And the last one I wanted to mention is Lydia's Law, which was introduced earlier this year as a private member's bill by MPP Fife. The goal of the bill is to increase accountability and transparency in the handling of civil sexual assault cases. And it was driven by all the cases being thrown out with the Jordan principle. That was some of the momentum for it. It suggests a lot of changes in oversight. We touched a bit today about the fact that it's not being tracked how many are being tossed, right? This bill has some of that in it. It's asking for it. It's going to die at committee, I'm sure. It's not actually going to be passed, but there are good things in it. And our office met with MPP Fife a few times in order to come up with or help or discuss with her some things that could be added. There is also something in the bill about looking at that quick response program and seeing how it's working, which is a big focus of mine. So I'm happy to see that there, even though it's going to likely die. But without further ado, those are the exciting bills I have to talk about.